So if we went till chapter summary trials, all those things we have finished. Judgment దగ్గర ఆగాం మనం. జడ్జిమెంట్ చేద్దాం అనుకున్నాం కదా. We thought we'll do judgments. Okay, important chapter లో ప్లీ బార్గెనింగ్ కూడా చేసాం మనము. We did up to plea bargaining వరకు చేసాం. సమ్మరీ ట్రయల్ చేసాము. ఓకే, ప్లీ బార్గెనింగ్ ఇవి చేసాము. దెన్ వి థాట్ అదర్ చాప్టర్స్ ఆర్ నాట్ ఇంపార్టెంట్. ఓకే, సో వి విల్ గో టు జడ్జిమెంట్. అది ఇంపార్టెంట్ అనేది చెప్పాము. ఓకే, జడ్జిమెంట్ కన్నా ముందు కూడా ఇంకోటి ఏంటంటే డిస్పోజల్ ఆఫ్ కేసెస్ వితౌట్ ఫుల్ ట్రయల్ అనేది ఒకటి ఉంటుంది. ఇది కొంచెం కాన్సెప్ట్ బేస్డ్. ఎందుకంటే ఫుల్ ట్రయల్ లేకుండా వాట్ టైప్ ఆఫ్ కేసెస్
disposed
can be disposed. The abortive trials, we call it abortive trials. So trial is not finished. Okay, so without full trial, cases will be disposed. So we'll make it fast. Absence of complainant. Okay, in some cases where the complainant is absent, there the court will dispose. I mean, they will acquit the accused. So there are only few type of cases. So where absence of complainant will section 247 to 256 speak about these things. Okay, main thing about this is, okay, the offense is compoundable. The offense is not cognizable offense. The proceedings have been instituted upon complaint. The charge has not been framed. So when they complainant individually, private complaint, I'm not talking about through charge sheet, through police FIR. So if the complaint is given by a complainant, it is his duty to attend the trial. Every day trial he has to attend. I mean, whenever the date is given, whenever the matter is listed, he must attend the trial. So if he is absent, so he can be absent, so they will excuse couple of times, but he is absent continuously, then they will acquit the accused. Okay, so similarly, withdrawal of the complaint. So withdrawal of the complaint under section 257. So withdrawal of the complaint is also, if it is a private complaint, FIR is not made and charge sheet is not framed. So mostly it will happen in someone's cases, small cases. Even in if FIR is framed, if it is a someone's case, they will refer it to Lok Adalat and get it, withdrawal can be done. Okay, so here magistrate is having discretionary power for withdrawal if it is through FIR. Even in some cases, magistrate will allow for withdrawal. Sometimes he may not allow withdrawal even if it is a complaint related case. Okay. Then autrefois acquit, autrefois convict. So what is autrefois? See, they may ask, this is concept based. Autrefois acquit, autrefois convict. This section 300, this particular thing has come in a question. Okay, I mean previous year question. Autrefois acquit, autrefois convict. So this is the basic principle of natural justice where we studied in Constitution also. A person once convicted or acquitted shall not be tried again for the same crime. So if the crime already, it is the particular person, he is convicted in the crime, so again they are filing another case against that particular person, the court will dispose of that case without full trial, because already he is acquitted or he is convicted in the previous trial. So they will not do the same trial for the same crime again. Okay, autrefois acquit, autrefois convict means a person convicted once or acquitted once cannot again, same cannot be tried again. Okay. Then principle of
Sir,
issue of
repeat sir, a person.
ఎప్పుడైనా ఆ పర్సన్ ఒక్కసారి అక్విట్ అయ్యాడు, ఒక్కసారి కన్విక్ట్ అయ్యాడు అనుకోండి, ఇంతకు మొదలు సేమ్ కేసు లోపల అదే కేసు మళ్ళీ పెట్టేసి ఇంకోసారి పనిష్ చేయడానికి లేకపోతే ట్రై చేయడానికి కుదరదు.
ఓకే సార్.
ఓకే, డబుల్ జియోపార్డీ అని ఉంటుంది ఒకటి.
డబుల్ జియోపార్డీ
లాంటిది. ఓకే, ప్రిన్సిపల్ ఆఫ్ ఇష్యూ ఆఫ్ ఎస్టోపెల్. ఓకే, ఎస్టోపెల్ అంటే ఆల్రెడీ ఒక్కసారి మన మాట విన్నాం చెప్పామనుకోండి, ఆ మాట కట్టుబడి ఉండడాన్ని ఎస్టోపెల్ అంటాము. ఓకే, మనం కోర్టులో ఒక స్టేట్మెంట్ ఇచ్చాము, ఆ స్టేట్మెంట్ బేస్డ్ గానే ఇంకోటి ఉంటుందన్నమాట. ఓకే, సో ఎగ్జాంపుల్ వచ్చేసి నేను ఒకటి చెప్తాను మీకు. ఓకే, ఒక కేసు ఉంది, మీ కేసు కూడా లా కూడా వస్తుంది, నేను ఓపెన్ చేస్తాను. ప్రీతం సింగ్ వర్సెస్ స్టేట్ ఆఫ్ పంజాబ్. ఓకే, ఇన్ దిస్ కేస్ ద previous case anamata, this is not the same, there are two cases. In one case the accused was tried for possessing a revolver without license. So accused is Pritam Singh, he was tried for possessing a revolver. Atani దగ్గర రివాల్వర్ ఉందని కేసు వేశారు. సో కోర్ట్ అతన్ని అక్విట్ చేసింది. కోర్ట్ acquitted him that okay, there is no revolver with him and there is no evidence, proper evidence, and police couldn't prove that he was having any revolver with him. Okay, then there is another case after that, that accused used that revolver to kill some other person. Okay, so already there is a issue of estoppel that atani దగ్గర రివాల్వర్ లేదని ప్రూవ్ అయిపోయింది in the previous case లోపల. సో ఈ కేస్ ని కూడా డిస్పోజ్ చేశారు, బికాస్ there is no revolver with him, how can he kill with revolver అనేది అతని దగ్గర ఎప్పుడు రివాల్వర్ లేదని ప్రూవ్ అయింది ప్రీవియస్ కేసు లోపల. సో నెక్స్ట్ కేసు లో అదే రివాల్వర్ తోటి చంపాడని ఉంది. ఓకే, so without trial, because already it is proven in previous case, so they have released that person. Okay, అర్థమైందా మీకు? ప్రీవియస్ స్టేట్మెంట్స్ తోటి ఈ కేసులో ట్రయల్ చేయాల్సిన అవసరం లేదని రిలీజ్ చేశారు ప్రీవియస్ కేసు రిజల్ట్ బేసిస్ లో. Okay, got it?
Yes, sir.
Yes, sir.
సో
Yes, sir.
టెండర్ ఆఫ్ పార్డన్ లో కూడా చేస్తారు. ఎందుకంటే బేసికల్ గా గ్రూప్ గా ఉంటారు, ఒక 10 మంది 20 మంది పోయి చేస్తారు ఏదైనా బస్సును తగలబెట్టడం అది ఇది. సో ఒకరిని ఐసోలేట్ చేయడం కష్టం ఉంటుంది. ఓకే, సో అందులో ఎక్కువ మంది ఉన్నప్పుడు, అకంప్లీస్ ఉన్నప్పుడు అతను విట్నెస్ అయ్యాడు అనుకో, అప్రూవర్ అయ్యాడు అనుకో, అప్రూవర్ అంటాం కదా. సో 5 మంది కలిసి చేశారు, సో ఎవరు చేశారు అందులో అనేది తెలీదు. సో ఎవరైనా అందులో అప్రూవర్ అయినప్పుడు అతనికి పార్డన్ చేస్తారు అనమాట, అతను ఎక్స్క్యూజ్ చేస్తారు. చెప్పండి. ఓకే, టెండర్ అంటే ఇందులో కంప్లీట్ చేయరు అతని పైన ట్రయల్ ని. అన్నిటికన్నా ఇంపార్టెంట్ ఏంటంటే కాంపౌండింగ్ ఆఫ్ అఫెన్సెస్, ఇది అన్నిటికన్నా ఇంపార్టెంట్ చాప్టర్. సో ఇది మనం చాలా యూజ్ చేస్తాము చాలా కేసెస్ లో. కాంపౌండింగ్ ఆఫ్ అఫెన్సెస్ ఇస్ అండర్ సెక్షన్ 320. దిస్ ఈస్ వెరీ ఇంపార్టెంట్, అందుకే దాన్ని బోల్డ్ చేశాను. దిస్ ఈస్ ఈ రోజు నేను హైకోర్టులో దీని గురించే అపీల్ పిటిషన్ వేశాను కాంపౌండింగ్ ఆఫ్ అఫెన్సెస్ లో. సో కాంపౌండింగ్ ఆఫ్ అఫెన్సెస్ ని మనకు టేబుల్ 1, టేబుల్ 2 ఉంటుంది మన సిఆర్పిసి లో వెనకాల, ఆర్ బిఎన్ఎస్ఎస్ లో బ్యాక్ సైడ్. ఓకే, ఫస్ట్ షెడ్యూల్ అండ్ సెకండ్ షెడ్యూల్. సో ఈ షెడ్యూల్ లో లిస్ట్ ఆఫ్ అఫెన్సెస్ విచ్ కెన్ బి కాంపౌండెడ్ విల్ బి దేర్. Okay, there is one list which can be compounded directly. There is another list which can be compounded with the permission of the magistrate. Okay, section 320 లో మనకు లోక్ అదాలత్ కి రిఫర్ చేస్తారు. కాంపౌండింగ్ అంటే ఏం కన్ఫ్యూజ్ అవ్వద్దు, కాంప్రమైజ్ ని కాంపౌండింగ్ అంటారు. ఏంటి కాంప్రమైజ్? ఇద్దరు కలిసేసి ఒకరినొకరు ఓకే మేము అవుట్ ఆఫ్ కోర్ట్ సెటిల్ చేసుకుంటాము, ఈ కేసుని మ్యూచువల్ గా డిస్కస్ చేసి మేము సెటిల్ చేసుకుంటాము అనేదాన్ని కాంపౌండింగ్ అంటారు. సో క్రిమినల్ కేసెస్ లో కాంపౌండింగ్ అన్ని కేసెస్ ని అలౌ చేయరు. సో దేర్ ఆర్ సర్టెన్ కేసెస్ వేర్ కాంపౌండింగ్ ఈజ్ అలౌడ్. సో యు నీడ్ నాట్ వరీ, దట్ సెక్షన్స్ ఆర్ దేర్ ఇన్ షెడ్యూల్ 1 అండ్ షెడ్యూల్ 2. షెడ్యూల్ 2 కి magistrate permission is mandatory for compounding. Schedule 1 you can compound directly. Okay, then section 321 talks about withdrawal from the prosecution. Public prosecutor withdraw chesukochu konni cases ni, okay, with the permission of the court, okay, before charges are framed. And criminal proceedings barred by limitation. Okay, so there are certain limitation act applicable అవుతుంది. Okay, ఇక్కడ section. Okay, so limitation act applicable అవుతుంది కొన్ని దీనికి క్రైమ్స్ కి. Okay, where the punishment is less than 3 years maximum. So the case should be filed within 3 years. And if that 3 months, 6 months punishment untundi for certain cases, petty crimes. So for that, you cannot keep on, say, if something happened now, the punishment is 3 months. You cannot file a case after 1 year. You cannot file a case after 6 months for those punishment crimes. Okay, so limitation period is there. So if such cases are filed, those cases will be dismissed without full trial, where complete if the case is filed after limitation period. Okay, those things are 468 to 460, 473 talks about those things. But 473 talks about extension of limitation period in certain cases. Okay, కొన్ని కేసెస్ లోపల కోర్ట్ కి పవర్ ఉంటుంది. సెక్షన్ 473 లో లిమిటేషన్ పీరియడ్ ని దే కెన్ ఎక్స్టెండ్ ఇట్. So next important topic is judgment 27. Okay, chapter 27, sections 353 to 371 is judgment. Appeals is 372 to 394. Okay, 353 to 394 is from judgment and appeals. These chapters are so these all are important chapters. 27, 29, 28. Okay, 29, 28 is not so important. You can mark it. So 20 appeals is also important. Okay, 30 is important. Reference and revision is important. Okay, then bails and bonds 33 is another important chapter. So you can expect questions. Other things you will get questions from BERAC directly. Okay, here some concepts are important. So what is judgment? Okay, so judgment is the final decision of the criminal court determining the guilt or innocence of the accused and prescribing the sentence if convicted. Okay, so judgment is the final decisions of the criminal court. If the case will be filed in a criminal court only, we are talking about criminal procedure code, right? So this case is filed in a criminal court, magistrate court or sessions court. So the court will determine whether that particular person is innocent or is not innocent. Guilt, let us say. Okay, he is guilt or innocent. If he is guilty, he will be sentenced, convicted. If he is not guilty, if he is innocent, he will be acquitted. Acquitted ante atani మీద punishment ఏం ఉండదు. అతని కేస్ ని కొట్టేస్తారు acquittal అంటే. Okay, case will be dismissed against that particular accused. Okay, so it must be, judgment must be clear, unambiguous, ante confusion ఉండకూడదు, క్లారిటీ తోటి ఇవ్వాలి. Reason why he is convicted or why he is acquitted, that reason should be very clear. So convicted, all evidences are against him. When cross examination proved, everything is proved that he is conviction ki reasons ఇవ్వాలి. Same time acquittal ki why he is innocent అనే దానికి reasons ఇవ్వాలి. So in the cross exam they couldn't provide proper evidence, all those things. So he is acquitted and it should be pronounced in the court. Court lo pronounce cheyali. Okay, court lo general ga anta judgment chadavaru chinna courtలలో. They will say dismiss చేస్తున్నాం కేస్ ని. ఓకే, నేను పనిష్ చేస్తున్నాము 3 years punishment అలాంటిది ఏదైనా ఒక 2 సెంటెన్స్ చెప్తారు. Okay, but they will not read out that entire judgment. You have to, they will give you a copy of judgment and you have to take it. Okay, so ఎలా ప్రొనౌన్స్ చేస్తారు? కోర్ట్ will pronounce the judgment. Delivering the whole judgment or reading out the operative part, explaining the substance of the judgment. It can be done in 3 ways. delivering the whole judgment. He can give whole judgment or operative part. Okay, you have to pay 10,000 rupees fine. That is the operative part. Or substance of you, we are imposing fine. That is the substance of the judgment. You are convicted, we are imposing fine. Or you are convicted for the so and so, we are imposing 10,000 rupees fine. That is the operative part. Whole judgment is so and so. This evidence is presented. These people gave cross-examine. In the cross-exam, this is found. Okay, all those things are in the judgment. So you read one or two judgments in criminal cases, you will find out how the judgment will be there. That will be the best way. So you can download in the e-courts judgments. You read the judgment, one or two judgments in check bounce cases, one or two judgments in theft cases, one or two judgments in POXO cases, one or two judgments in murder cases, attempt to murder cases. So there will be around 10, 12 judgments. Try to read in criminal cases. You will understand how the judgment is structured. Okay. What is the operative part? What is the whole judgment? What is the cross-examination? Everything you will understand once you go through the judgment, and it will help you in framing your cross-examination in future also. Why the judge was impressed with this one? Why evidences was not proper, or why evidences are good? Okay. So all those things you will understand in this whole judgment. They will be describing those things. So contents of the judgment. Here, I already told judgment must be in the, okay, this is very important. People will ask, what is the language of the court? Okay, this will be question. So language of the court will be determined by the state governments. So High Court, it is English only. But in states like a few Hindi speaking states are there, UP, Bihar, Rajasthan, Madhya Pradesh, maybe one or two other states. There, Hindi is the language of high courts also. Okay, they speak in Hindi also in those courts. But in South India, high court, all proceedings happen in English. So everything happens in English. District courts, they can happen in English or Telugu. But here the practice is all the judgments, everything is given in English only. Because when they go for appeal, it should be convenient. That is the reason they are using English as a medium. But you can argue, you can cross-examine in regional language, in Telugu. It is no issues. Okay. But as per the CrPC, language of court is essential. So language of court will be Supreme Court. It is English only. High courts, except few courts, all other courts, it is English only. 4-5 courts are there, Hindi built. They use Hindi as a language. So judgments and all those things, your petitions, pleadings, everything can be in language of the court. So here you can, even in Hyderabad or Telangana or Andhra Pradesh, you can give your petitions in regional language. Okay, there is no bar, because already state government, it is their language of the courts in districts is Telugu is also there. But most of the time they don't understand. So translation is required. They may impose costs on you only. So that is the reason we most of the time we use English as a language for drafting. Okay. So you can draft your plains and those things in regional language. But again, they may ask you to translate. So that is the only challenge. So people from beginning, we are doing in English only. Okay. Because once we transfer those cases for appeals into district court, from there to high court, then everything is gone. If it is in regional language, again, it should be translated. It will be delayed, all those things. So from beginning only, they are using English, so that even if they go for appeal in high courts or if they go for Supreme Court, there is no need of translation for judgments or appeals or plaints, pleadings, all those things. That is the only reason we are using English. Otherwise, it can be any language. Language of the court, that is, you have to understand, this is the state government will determine what is the language of the courts. Okay, except in 4 high courts, all other courts, it is English only. Okay. Section 355, in petty cases, trials, the magistrate may record only a brief judgment. Okay, 356 judgment to be given to accused in certain cases, compensation to victims out of fine imposed. So in 357, this is very important when wrongly jailed, they will give compensation to victims also. Okay, some victims they will be given compensation where the accused has to pay compensation. Okay, victim compensation scheme is there, legal services is there. So those 357, 357D explain those things. Here 358, when accused is arrested without any proper ground, compensation is given. 357 talks about to the victims. 358 talks about to accused. Okay. So 359, payment of costs in non-cognizable offenses, probation of offenders. Okay. Must be recorded. So court cannot alter review judgment once signed. Okay, this is another important. Section 362. Court, I made it. That is the reason I have highlighted here section 362. Court cannot alter review judgment once signed, except if there are some clerical errors. So they may ask you review of judgment. So once judgment is signed, there is no review. Okay, we'll talk about revision later. But so only for clerical errors it will be reviewed. Okay. So copies of judgment to be supplied to the accused. Okay, accused will be given copies. Okay, why they have to? Because you have, when you go to High Court, you have to go with the stamped copies only. You cannot go with a photocopy to High Court for appeals. Okay, you have to go with the judgment copies to the High Courts, or you have to apply for a CA copy and go to the High Court. So this is another important this thing, that is reference. Okay, what is reference? So this is section 395 onwards. Okay. I think we have missed appeals. Okay, we'll talk about appeals later. Okay, appeal is you can go for appeal in higher courts. Okay, I didn't speak about IP. Okay, so you can go for appeals in higher court. So if you are convicted or acquitted, if you are acquitted, if it is a private complaint, complaint will go. If it is through police, police may go for appeal in higher courts. If you are convicted, you will go to the next higher court for appeal. Even if you are convicted, let us say you are convicted for a crime, the public prosecutor and police are not satisfied with the sentence. Okay, so they were expecting 10 years imprisonment, but the court has given 5 years imprisonment. So they can go for appeal for enhancement of the sentence also. Enhancement of the sentence. So let us say murder case is there. So they may give 7 years punishment. So they may go for appeal for life imprisonment, or they may go for appeal for death sentence. Okay. So appeal, both parties can go, even if it is convicted. Okay, if it is convicted, both will go for enhancement or for appeal. If it is acquitted, only one party will go, that is police or the complainant will go for appeal. Okay, so appeal will be they go to the higher courts for the appeal. I think we have come. Okay, reference. Reference is under section 395 and 396. What is reference? Okay, so reference is a lower court asking the higher court, okay, for guidance in some particular, they are asking guidance from the higher courts. Okay, the guidance can be any law which is not clear to them, or whether any validity of law is doubtful, whether they can apply that particular law in this case or not, or there is a substantial legal question. So instead of deciding wrongly, they will refer that question to High Court. So once the High Court give the opinion, then the lower court will proceed according to that reference. Okay, if there is any question on law, whether there is any question on that, when there is a doubt for lower courts, they will ask that particular, they will refer that particular question to the High Courts. Then High Court guide them and they give clarity about that particular law, about that legal question or validity. Once that doubt is clarified, then the lower court will proceed the trial regularly. Okay, this is asking clarification from the higher courts if there is any law is not clear. Okay, here revision is not clarity. Already lower court has taken order or judgment. So high courts will check whether it is proper or not proper. Okay, so they will send it back to the sessions court and ask them to examine again. Higher court, so it is not like appeal. Appeal is, it is full appeal. You will not, lower court records or mistakes or anything will not be corrected there. New judgment will be given in appeal. Okay, in appeal, new judgment will be given. In revision, the judgment will be corrected if there is any improper things. Okay, you got it. So in revision, the judgment or orders will be revised. They will be changed. Correct mistakes will be corrected. Okay, but appeal, it is new order will be given.
So what is the exactly difference?
అంటే అపీల్ అంటే నీకు పాతదాన్ని చేంజ్ చేయట్లేదు. నీకు ఒకటి జడ్జిమెంట్ ఇచ్చారు, ఇది తప్పు ఇచ్చారు, ఇది చేంజ్ చేస్తున్నాము, ఇది జడ్జి కరెక్ట్, జడ్జి ఇది ఆర్డర్ కరెక్ట్ కాదని చెప్తున్నారు. ఓకే, అపీల్లోనేమో నువ్వు కొత్త కేసు వేస్తున్నావు, కొత్త ట్రయల్ చేస్తారు అక్కడ మళ్ళీ హైకోర్టులో. ఇక్కడనేమో జడ్జిమెంట్ లో కరెక్షన్ చేస్తున్నారు. ఇది తప్పిచ్చావు, ఈ సెక్షన్ అప్లై కాదు, ఈ సెక్షన్ తీసేయాలి, ఇది తీసేయని చెప్తారు. ఇట్ ఈస్ నాట్ ఏ ఫుల్ అపీల్. కొంచెం అపీల్ లాంటిది కానీ ఫుల్ అపీల్ కాదు.
అంటే మైనర్ కరెక్షన్ లైక్ రివిజన్
కరెక్షన్స్ చేస్తారు అందులో. ఇది తీసేయండి, ఇది తీసేయండి అని చెప్తారు. ఓకే, అపీల్ అనేది మనం ఆ కోర్టుకి సంబంధం లేదు, మళ్ళీ అదే కోర్టులో ఉంటుంది. రివిజన్ లో మళ్ళీ అదే కోర్టుకు వస్తుంది. ఎక్కడైతే రివిజన్ పోయిందో అపీల్ వేరే కోర్టు జడ్జిమెంట్ ఇస్తుంది. ఇందులో ఆర్డర్, కొత్త ఆర్డర్ రాదు. పాత ఆర్డర్ ని ఇప్పుడు సెషన్ కోర్ట్ ఆర్డర్ ని రివిజన్ చేశారనుకోండి, సెషన్ కోర్ట్ ఆర్డర్ గానే ఉంటుంది, హైకోర్టు ఆర్డర్ కింద రాదు అది. అపీల్ ఏమో హైకోర్టు ఆర్డర్ వస్తుంది నీకు.
బట్ విచ్ ఇస్ ఫైనల్? సో దట్ మీన్స్ సమ్టైమ్స్ అపీల్ విల్ బెటర్, సమ్టైమ్స్ రివిజన్ విల్ బెటర్, రైట్?
కొన్నిట్లో రివిజన్ అవుతుంది, కొన్నిట్లో అపీల్ అవుతుంది, డిపెండింగ్ ఆన్ ద కేస్ టు కేస్.
ఓకే
ఓకే, సో నువ్వు అపీల్కి వెళ్ళావనుకో, అపీల్ కి కొత్తగా రెగ్యులర్ గా ట్రయల్ చేస్తారు, రెగ్యులర్ గా చేసేస్తారు. ఏది హైకోర్టు ఆర్డర్ ఇచ్చేస్తుంది దానికి, అపీల్ కి. రివిజన్ కి హైకోర్టు ఆర్డర్ ఇవ్వదు, ఆ పాత కోర్టు ని కరెక్షన్ చేసి కొత్త ఆర్డర్ ఇవ్వమంటుంది వాళ్ళకి. ఓకే, కింద కోర్టుకే ఇది మీరు కరెక్షన్ చేసుకోండి, ఇది కరెక్ట్ లేదు దీన్ని అని మళ్ళీ కింద కోర్టే ఆర్డర్ ఇస్తుంది, కొత్త ఆర్డర్.
There is some legal maximum. I forgot that. Yeah, I understand.
Okay. So bail. So bail is a right. Okay. If a person is accused of a bailable offense, bail must be granted as a matter of right. Okay. So general ga bailable offense aithe police valle bail ichestaru. So they will ask him to come and attend in the court directly. Station bail antam danni. Okay. If it is non-bailable offense, then magistrate, it is discretion of the magistrate. In all bail is not automatic. So you have to file a bail petition in the court. Then it is the discretion of the magistrate to give bail or not. So magistrate, you will apply, you can apply for second, third, fourth, fifth time. You can apply any number of times for the bail after some gap. If the magistrate is not giving the bail, you can apply in the sessions court. If the sessions court is not giving, you can go to high court. You can go up to Supreme Court also for bail. Okay. So bail general ga, if it is murder, rape, atlanti dan tappa chinnadaniki first or second attempt lo ichestaru. Okay, second petition lo ichestaru, or sessions court will give the bail. But if it is serious crime, then you have to fight strongly for the bail until unless that they will say that investigation should be over. Investigation అయిపోయిన తర్వాత bail ఇస్తారు. Okay, once the trial commences, mostly they will give the bail. But if the investigation is not started, they may not give the bail. But most cases, not so heinous crimes అంటాం కదా, heinous crimes కాని దానికి బెయిల్స్ ఇచ్చేస్తారు. ట్రయల్ కాకుండానే ఇన్వెస్టిగేషన్ కంప్లీట్ కాకుండా, పోలీస్కి ఇన్వెస్టిగేషన్ కాకుండా కూడా చాలా దానికి బెయిల్స్ ఇచ్చేస్తున్నాం మనం. దొంగతనంకి, చిన్న చిన్నది చీటింగ్ కేసెస్ కి, వాటికి వీటికి అన్నిటికి వీఆర్ గెటింగ్ ద బెయిల్. ఈవెన్ ఫర్ అటెంప్ట్ టు మర్డర్ ఆల్సో దే ఆర్ గివింగ్ ద బెయిల్. But murder, it will be difficult to give bail immediately. It will take time for murder and rape. Okay, and POCSO related cases and some other related cases, it will be difficult. But all other cases, for small cases, you get it in first or second attempt. Other cases, 4-5 attempts, you will get the bails. Okay, so it may take 1 week to 3 months for getting bails, depending on the offense and depending on the advocate also.
సార్
చెప్పు
సార్, మర్డర్ కేసు ఓన్లీ డిస్ట్రిక్ట్ కోర్టులోనేనా సార్?
సెషన్స్ కోర్ట్ లో పెట్టుకుంటావు నువ్వు, ఎందుకంటే దాంట్లో సెషన్స్ కోర్ట్ లోనే వస్తుంది మర్డర్ కేసు సెక్షన్ బట్టి. సో దానికి యాంటిసిపేటరీ బెయిల్ కి అప్లై చేసుకోవచ్చు. దానికి యాంటిసిపేటరీ బెయిల్ ఇప్పుడు ఉంది కదా చెప్తున్నాను. యాంటిసిపేటరీ బెయిల్ నీకు ఒకవేళ నీకు ఎఫ్ఐఆర్ ఫైల్ అయిందని తెలిస్తే, ఓకే, యాంటిసిపేటరీ బెయిల్ జస్ట్ నౌ వి డిస్కస్ బిఫోర్ ద సెషన్ స్టార్టెడ్. So anticipatory bail will be given if there is the apprehension that you will be arrested. అంటే నీకు అరెస్ట్ అవుతాడని భయం ఉంటే యాంటిసిపేటరీ బెయిల్కి వెళ్తావు, సెక్షన్ 438 కింద వెళ్తావు. సో ఓన్లీ సెషన్స్ కోర్ట్ అండ్ హై కోర్ట్ are having powers to give anticipatory bail. Even Supreme Court is having the power to give anticipatory bail. Okay, so it is a protective order, and you will not leave country, you will cooperate with investigation, all those conditions will be imposed. So they will not arrest you. You can take anticipatory bail if you fear that they are going to arrest. If they arrest, then it is a regular bail. If you are not arrested, applying for the bail, it is anticipatory bail. Anticipatory bail you have to apply only in sessions court. Magistrate is not having power to give anticipatory bail. Magistrates only give regular bails. Okay, so ఇప్పుడు somebody was asking, okay, so bail, serious offenses, normally magistrate will not give. It will go to sessions court or high court only. For murder, all those things you have to take it from sessions court only. Magistrate court la above. Okay, in special situations, 436A, under trial prisoners who spent half the maximum sentence in jail can be released on bail with some exceptions. Okay, if there is a crime, say let us say attempt to murder, 7 years imprisonment undi, vadiki bail ivaledu, he is not in a position to afford for bail or hire advocate, whatever it is. So 3.5 years imprisonment aindi, so maximum sentence under that IPC section is 7 years. So if he completes 3.5 years, default ga bail icheyochu. More than 50% of the maximum sentence in jail, he will be released. Okay, so court lo personal bond ichesi వెళ్ళిపోవచ్చు అతను. సో కోర్ట్ బెయిల్ బాండ్ డిసైడ్ చేస్తుంది. హౌ మచ్ బాండ్ గురించి చెప్పాం కదా, షూరిటీ ఇవ్వాలి, how much money, all those things. It can be personal surety or it can be people will give property papers in the deposit, property papers in the court, or they deposit fixed deposits in the court. So court will say 10,000 rupees deposit. If they say 10 lakh rupees, so you don't have 10 lakh rupees, so you will get your property papers with a valuation certificate. I mean market value certificate, registrar will give. So market value plus your property paper you can deposit if it is more than 10 lakhs. Some cases courts will ask 5 lakh rupees deposit, 10 lakh rupees deposit. So why? Because if the person whom you are giving bail surety, if the accused is absconding, then this will be forfeited. Okay, so here procedure for forfeiture of bond is also there under this section. So those properties first they will proclaim, they will announce that the person is absconding, then the sureties what they have given as surety will be forfeited by the court. Court will take that property, court will take that FD, it will encash that FD, or they will attach the property.
But in real case it will happen, sir. It may happen.
Yes, నేనే ఫోర్ఫిట్ చేయించాను కొన్ని కేసెస్ లో.
మళ్ళీ దానికి సార్ ఎగ్జిబిట్ మధ్యలో పెట్టి ఆయనతోని ఎగ్జిక్యూట్ చేస్తారా సార్? సేమ్.
See, actually గా నాది, I'll tell you, in my case it is a fixed deposit. 10,000 rupees fixed deposit sureties is given. So the person died actually. The accused died. And the sureties are also not coming. So the
Okay.
case cannot be closed. Okay,
Okay,
case
sir.
cannot be closed. So case close చేయాలంటే దానికి పెద్ద ప్రొసీజర్ ఉంటుంది. సో ఇది ప్రైవేట్ కంప్లైంట్, ఇట్ ఈస్ నాట్ ఏ పోలీస్ కంప్లైంట్. సో ప్రైవేట్ కంప్లైంట్ కనుక నేను ఐఎమ్ ఫైటింగ్ ఆన్ బిహాఫ్ ఆఫ్ ద కంప్లైనెంట్. సో if it is a police complaint, I will not go. It will be public prosecutor who will be going. So this case is against 10 people. So they have taken deposits from public and they have run away. Finance company. Okay. So
Sure,
I am representing Reserve Bank of India in a case. So they are not appearing. 10 people, out of 10 people, 1 or 2 people are appearing. All 8, out of those 8, 4 or 5 people have died. So when court asked what happened to these people, see, we cannot produce death certificate because we cannot get the death certificate, right, for third party death certificates. So I told, like, I'm helpless, I don't know, we cannot trace him. They might have dead also because see, their age will be 90 years. So that is the only reason I told they will be not alive.
But
Chances are very less.
one latest thing, sir, in the court, they are not accepting 60 plus 70 plus years surety also, but it is unofficial, right, sir?
No, yeah, no, they will accept that it is different. Sometimes they may accept, but since see, this is 20-year case, old case. Okay, so now there will be 80-year-old. Okay, so the chances of them alive is also very less. Not I'm talking of the convict. Okay, the accused was at the time was 60 years. Now it is 20-year case, 22, 23 years old case. So he will be above 80 plus. So the chances
Correct.
of him is alive is very less. So we gave a paper notification that this person is absconding because we don't have a death certificate with us. So after proof, then we have issued notices to the sureties. Please come and attend because this person is not attending. So the sureties can come and produce the death certificate, then it is okay. Here the sureties also haven't come. So since sureties also haven't come, then the court forfeited the deposit. Okay, this is the process. Yeah, tell me, you are asking something.
Yes, sir. Yeah. No, and nowadays it's a very live case. I experienced that. The judge madam was sometimes in some cases sureties are above 65 years, 70 years. They're straight away telling, no, we don't entertain such kind.
Yes,
Please.
see, because the sureties, let us say sureties will, we have to see to that sureties responsibility. What is the responsibility of the sureties? When you are giving bail, the judge will ask, make sure that this person is attending every adjournment, every case it is listed. So the accused should attend the case on all days, listed case. Okay. So it is the responsibility of the sureties. So if the surety is 65 years old age and the case goes for 10 years and the surety dies, then there is no responsibility of the surety, right, to send this person.
But same thing now, what you did, same way it can be closed, sir?
No, it will see. Yeah, it will a proclamation. Then the person is not attending the case. The surety will be forfeited. But if the surety is died, then court may ask to replace the surety with another surety. That money can be taken back.
Then that is fine, no, sir. Yeah.
Yeah. So if the accused is there, then they can say that we are replacing the sureties or he's not well. You can replace the sureties. Our surety can come to the court and he can say, I'm withdrawing myself from the surety. Then the accused court will ask the accused to bring in another surety. Those things will be there.
Okay, sir.
Okay.
But there is no official any memo or something like that. So, but it depends upon judge to judge, right?
No. You can file a petition that I am withdrawing as a surety or the surety
I'm
is
not
died.
talking about that one, sir. Age of the surety. There is no
age
official...
of the surety. So I didn't face anything like that. Normally, I had to check because nowhere in the law age is mentioned.
Yeah, that is what, sir. As per my knowledge, my senior also, he said it can take anyone. But nowadays they are not entertaining. It is person to person. It is changing, sir. Judge to judge, individual.
Yeah. So that is the thing.